231. The state appears by General Zepeda. The defendant appears. So this file does not show that an attorney has entered an appearance in either of these files, but on request of the state, I reviewed the civil file, and it was as a result of that review I summarized the order that was entered, and we scheduled this hearing for the power of attorney Brian Collins to appear. Mr. Collins is here, and then the defense attorney in the civil case, Mr. Phillips.
It's Philip Lawrence.
Philip Lawrence, thank you, Mr. Lawrence. And the prospective defense attorney, Mr. Rogers. All right, so have you all been talking about what's going on here?
We have not. I haven't spoken to anyone.
Mr. Rogers.
Okay, and I'm not certain exactly why you were asked to be here. That was on request of the state. I think it's really the power of attorney and Mr. Rogers. So how do you all wish to proceed? The court order in civil court allowed certain monies to be paid over to the power of attorney. The power of attorney was to retain the attorneys, and yet there's nobody retained here. And the court order that was under seal said 60 days after it entered, which was in February of 25, that Mr. Rogers could go back to the civil case and request additional funds. So I guess my inquiry is, has the power of attorney paid those? So Mr. Collins, why don't you come forward? Good afternoon. You can come to that microphone right there. All right, sir, I'm going to put you under oath. Please raise your right hand. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, so, General, do you want to ask?
Judge, I don't know that it's...
Judge, can we all formally go into the potential attorneys?
Sure. All right. Well, nothing's off the record in criminal court, but you can have a bench conference. So if Mr. Liner was coming forward, I was going to ask him to take a step away from Mr. Collins. All right, so, well, I think you're all right.
So do I need to step away?
All right. Just do whatever. At this point, I think Mr. Liner should be part of the bench conference. I'm not attorney of record. I think you should be part of this, Mr. Liner.
But following the court's security requirements,
State's position would be that we do not want to incur any additional delay in that case. But that being said, I don't know that it's appropriate for us to involve ourselves
lift its, or to modify the restraining order or injunction that it had imposed. And we had a hearing on whether or not the court was going to allow Mr. Rogers to be paid the balance of his fee. That was declined. The court also needs to know that early on I filed an application for an interlocutory appeal because I do not believe that the order that the circuit court entered is legal.
I looked at the civil file and I saw that there are assets, and then I was granted permission to look at the sealed order, and there were no money amounts listed in it but for the $150,000 that was to be paid over to the power of attorney. And then it said Mr. Rogers could come back at 60-day increments to get more money. And so that's the order that you think is illegal?
What I think is illegal is the fact that the judge put a limitation on Mr. Liner's access to his own money. There's no basis for it. There was no evidence to support a concern that the money would be dissipated, lost, hypothecated, or whatever. And I don't believe that there is legal support for what the court did in freezing Mr. Liner's assets. He has no access to it. The court has everything that he owns under a restraining order, and we asked the judge to relax that to allow Mr. Rogers to be paid the remainder of his retainer, and that was declined. The court may not have seen an inventory that was filed in the civil case. I was required to file an accounting of some kind to show what Mr. Liner owns, and it's in the neighborhood of $3.5 million. And the idea that he can't have access to a portion of that to hire counsel in this case is somewhat shocking. And so right now, despite the fact that he has that estate, he's maybe indigent.
Well, how can someone be indigent if they have $3.5 million?
Well, he doesn't have access to it. There's a legal barrier between him and his access to his money.
So did you file the appeal that you were seeking?
Well, let me tell you how that works. I file an application for an interlocutory appeal. I asked the judge for permission to appeal because I felt that his order was invalid. He denied the application for permission to appeal. However, there is a procedure under a different rule of procedure where you can ask for an interlocutory appeal even though the judge hadn't granted it.
Right.
And what the Court of Appeals has done, typically, I've done this in the past, if they don't think that they're going to grant it, they just put down an order denied. However, they have asked for an answer to be filed by the plaintiff in the case, and it seems to me that they will accept the case for to determine the legality of that order. Of course, their timing's their own, and the case marches on both in this court and in the civil case, notwithstanding the fact that that matter is there for the Court of Appeals to consider. What would happen is when the Court of Appeals decides to accept the appeal, an order will go down, and that will stay the process in the state court. If the Court of Appeals agrees with me, then there's a possibility that money would become available. At that point in time, Mr. Rogers may or may not be available. So someone else would have to be hired.
But was not there an order that said within 60 days Mr. Rogers can file for more money?
We did file for more money. It wasn't within 60 days. I was hoping that the Court of Appeals would act and we wouldn't need the court permission. back. It didn't matter whether it was within 60 days or whenever. We did go back, and the application, the request, whatever you want to call it, was denied.
So at this point, is it your understanding that no more money will be approved by the civil court for Mr. Liner?
What I can tell you is this, that notwithstanding the fact that Mr. Rogers had a contract with Mr. Liner to defend him, the court would not honor that contract. Now, is there a possibility that somebody could come by who was willing to represent Mr. Liner for a reduced amount and the court would approve that? I don't know.
And so what has happened to the $150,000 that was authorized by the court?
$100,000 was paid to Mr. Rogers as a partial retainer. My understanding is that he has appeared on several occasions in this case, not in this case, but in the General Sessions Court before Judge Collins. He's met several times with Mr. Liner. I think he made an appearance in this second indictment. It made an appearance when the charge was made in Sessions Court. So he's been paid a portion of his retainer. He's performed some services. The other $50,000, $25,000 was paid to me as a retainer in the civil case. And I will tell you frankly, that's been eaten up. $25,000 was paid to Mr. Collins to pay Mr. Liner's bills. He has ongoing bills such as child support. He's got a storage unit. He had a lease. I don't know what happened to the lease, but he had signed a lease at some point in time. Whether the lease payments are being made for an empty apartment, I'm unaware. But I do know that not all of the money paid to Mr. Collins as attorney in fact has been consumed. I think he indicated to the court that he has $11,000 remaining of that 25. The other 14 or 16 has been spent.
So, Mr. Liner, that kind of goes to you. Are you going to hire Mr. Rogers?
That is the planning, yes. Yes, that's the plan.
Well, we've got a trial date set. Your trial date is for May 12th of 2026. So that's 3 and 5, 8 months from now. So I can't let a civil case take precedence over a criminal case. Criminal cases always take precedence. The only court order that I saw didn't show any motions being filed for more money. It said the money was allocated, that requests could be made in 90 days to get more, but Mr. Rogers could make a request within 60 days. So I guess, Mr. Rogers, have you made any request of the civil court for money?
Mr. Morris requested on my behalf.
That's what I
did. That civil case. Mr. Morris did it for Mr. Liner, trying to get the retainer paid. It was denied.
And so that's after that sealed order went down, you went back and requested more money,
That's
and
correct.
the judge said no.
Said no.
Yet there are $3.5 million that is available to hire a lawyer.
You know,
Can I talk to Mr. Morris for a second? Because I don't want to tell you something wrong.
Sure.
Pardon our conversation.
No, that's all right.
You had a question and it went out of my mind. The short of it is we did go back and the request was denied. Mr. Rogers insisted that the contract that he had with Mr. Liner be honored. The court may have been willing to do something less than what was requested, but did not, what is specific about that. And also, there may have been conditions that the judge wanted to place on Mr. Rogers being paid that were, let's just say unacceptable. Whether they were reasonable or not, I won't judge, but they were unacceptable to Mr. Rogers. So, the only thing that could change, Your Honor, would be what the Tennessee Court of Appeals does with regard to the interlocutory appeal that would allow unlimited access by Mr. Liner to his own money.
And we don't know when that might occur.
Do not. I'll say this. I think it's close. I mean, it could be any day, but there's no predicting the Tennessee Court of Appeals. I've been there. I've had 100 appeals.
Your Honor, so the court knows this, I feel it's incumbent upon me to say this. I heard or saw some clip somewhere where Your Honor was trying to avoid or maybe thinking that Mr. Liner was trying to hold this up or use some kind of stall tactic. I can assure you as an officer of the court, Mr. Liner has been willing to honor his contract with me the whole time as far as I know, and he's told me over and over that I am the attorney that he wishes to hire for his defense lawyer in this case. I'm willing to honor the contract I made with Mr. Liner as a matter of my word, but on the terms that Mr. Liner and I agreed to, not on some other directive from some other court. And so that's why I'm not willing to go down as attorney of record, because that's not the deal I made with Mr. Liner.
So, Mr. Liner, I think this kind of puts it back in your ballpark. You've got a lawyer that you've got a contract with, and that's the only thing he'll accept. You have money, but the civil courts have said you don't have access to it. So are you wanting to go to trial and be your own lawyer, or do you want to hire someone else?
I'd like to proceed with Mr. Rogers.
But Mr. Rogers is not available. He won't do it without whatever the terms of your agreement are.
Can we proceed at this time, or?
We are proceeding right now. So what do you want to do?
I'd like to proceed with Mr. Rogers, but
He says he won't do it without the money. So do you want to try to hire someone else? Do you want to represent yourself?
yeah, represent myself.
All right.
Let us have a word with him about that, if you don't mind, Your Honor. I don't think Mr. Liner comprehends what his alternatives are.
All right. You can talk with him. Why don't you step away from the microphones? Mr. Collins, it sounds like you've got records for the money
Yes,
you
ma'am.
received.
And I've got records to where I spent the money.
Okay. And do you have any more money in your control other than for the rent and the storage?
That's all. I've got that $25,000 that Judge Sharp gave me, and what's left? It's $11,175 or something like that. Because once I got the initial bills paid, there's not any.
Okay.
And I gave Judge Sharp last week a full accounting, like one I've got on right here.
Okay, and when you say a full
That's
accounting,
just what
this
money
is
I spent since it was.
money that has come in and money that you've
Only
paid
money
out?
that came in was the $25,000 originally, and that's the money that I had spent out paying Mr. Liner's bills.
All right.
I paid the attorneys. I had $25,000 paid. I've just been paying the bills.
All right.
Judge Sharp wanted copies of the accounting, and I thought, well, want one, I'll have one for you too.
All right. Is there anything in this packet of information that is different than you gave to the civil
No,
court?
ma'am, it is exactly the same. Same bank statements, canceled checks, copies of bills I paid, what days they were paid. And I just had it lined up every month. Where I paid it, they do emergency, where the checks cleared the bank, the bills with it, I tried to keep it all organized.
All right. And is it true that you've paid $100 to Mr. Rogers?
$100,000.
I'm sorry, $100,000.
I did that right after the account was open, just like Judge Sharp said in the court order. I wrote everybody those two, their checks first.
All right. I don't, you're welcome to stay if you wish, but since you're operating under the authorities and the directives of the civil court,
Yes, ma'am.
then I don't know that there's anything else you can provide to
If you
me.
need any of this, you can let me know. I'm going to keep it and do it.
I think you should.
I think I should too. Thank you very much.
You're welcome. Mr. Liner, after consulting with these lawyers that are not your lawyers in this proceeding, what do you want to do in terms of going forward?
I'd like to have the court appoint me an attorney.
Well, how in the world can I find a man who has $3.5 million indigent?
Well, I guess the question is, how can you send him to trial in a murder case without an attorney?
Well, if he chooses to be his own lawyer, are you wanting to go forward and represent yourself?
No, ma'am.
All right, fill out an affidavit of indigence. I'll call you back up when you have it done. While I'm waiting, I'll take up Nina Frederick. Be the truth, the whole truth, nothing but the truth, so help you God.
Yes, ma'am.
So, Mr. Liner, are you employed? I can see that you're in the jail. I know that you're not working. Do you have income from any source?
Yes, some of the investments are paying like dividends, yes.
All right, so where you left that question blank, I'm going to write in as your scrivener, yes. And so you have investments that are paying interest and dividends. And how much interest and dividends do you receive monthly?
I'm not sure.
All right, do you have a checking account or a savings account?
I don't, but I think my power of attorney might have opened one up to pay bills.
Your power of attorney has an account with $11,000 from his testimony. Is that the money you're referencing? So if the state of Tennessee were to send subpoenas for records to all of the banks in this area, there would be no bank or institution that would have any checking or savings account in your name.
I think they've all been closed out, but I'm not 100% positive being in here.
You disclosed that you own an automobile. What is the make and model of that vehicle?
Land Rover Defender.
And you value it at $50,000? For the record, he nodded his head in the affirmative. Criminal court is a court of record. You've got to speak, so it goes into our digital recorder. Do you owe any money on that automobile?
No, ma'am.
The question is, do you own personal property valued at over $250? And you wrote yes. What is the nature of that property?
I didn't know if that was referring like to the automobile I put on there or...
Well, other than the automobile, do you own any personal property worth more than $250?
Yes.
What do you own?
Be some furniture.
And what is the value of your furniture?
I honestly don't know.
Do you own anything else worth more than $250?
No, ma'am.
Do you own any real estate?
No, ma'am.
You're in the jail, you have no expenses. The power of attorney described making payments on an apartment or bills that you have for which he's spending the money. Do you know what he was referencing?
Yes, ma'am. It's like I had signed a lease on an apartment here in town I was going to stay in because we'd sold our house or were in the process of selling it. So that was the lease he was speaking of.
And so how much were you required to pay per month on that apartment lease?
I think it's like $1,600.
And then I heard you say that you were going to live there while they were selling your house. Has the house sold?
Yes, ma'am.
And so is that part of the $3.5 million that is subject to the civil lawsuit?
Yes, ma'am.
So do you have any money other than this $3.5 million?
No, ma'am.
Have you taken any steps through the civil courts to seek money to hire a lawyer?
No, ma'am.
Were you present the day that there was the hearing where this freeze order was placed on your assets?
No.
Well, Mr. Liner, in spite of the fact that the only asset you have is the vehicle, but it is valued at $50,000 and it has no lien against it, and then the interest and dividends you get off of these investments, I am declining your request for appointed counsel. I realize that you are wanting to hire Mr. Rogers, but if he will not work unless you pay him, what is your plan?
I'm not sure. I would have to speak to my lawyers about that, and I'm not sure.
Well, you don't have a lawyer. That's the problem.
Yeah, I would speak to Phil.
What I am going to do is, I have already denied you appointed counsel, and the basis for that is not only do you have $11,000 in the account held by your power of attorney, I am told you have $3.5 million in assets that are subject to this freeze order. You have this Land Rover, and you've taken no steps whatsoever to seek release of these funds for your lawyer. But I find you are not indigent under the statute, and appointed counsel will be denied. So are you going to try to hire a different lawyer?
I'd like to speak to my Phil first, Phil Lawrence.
All right, do you want to speak to him today?
Yeah.
Is he still here? Good.
If I could speak, one thing in his evidentiary, in his behalf, if I need to be sworn or as an officer of the court,
You are an officer of the court.
Your Honor, all of his assets are under this freeze order.
So this $50,000 Land Rover,
Mr. Collins is in possession of that, holding it under the same order that all of his other assets are held. So the car is not an asset that he has. He has access to nothing that he owns. And let me say, you ask him whether he has made application. He has been in jail. He hasn't done anything. Anything that's been done in the way of seeking assets for his criminal defense have been actions that I have taken on his behalf. So when he says that he hasn't done anything, he personally has not, because he hasn't had the ability to walk out the door or do anything else to help himself. But I have done all that I can to see that Mr. Rogers got hired in the first place and paid in the second place.
are you willing to go back to Judge Sharp and explain to him that there is a May trial date and the attorney he wishes to hire will do nothing until he is paid?
I'll be glad to go back. However, going back would be simply repeating what we did last Thursday, because we went there. We had, I think, Mr. Rogers testified under oath at that hearing. He was sworn and gave evidence of the very facts that we are
And so,
addressing here.
was there a court order entered last Thursday, some sort of an order on August 14th?
There will be. The judge doesn't write orders automatically. It's up to me or the other lawyer to prepare an order to submit to him. And we had an intervening weekend, so that order is in preparation, and he will sign it. And it will say simply what I'm telling you, that an application was made and the application was denied.
All right.
And I'll be happy to make that available to the state and to the court as well. I don't know what the protocol is about direct communication with the court, but I can certainly have that done.
And do Do you have another date when you're going back to Judge Sharp?
Yeah, for the trial of this case, a summary judgment was granted on the issue of liability. There is a trial date in late October on the issue of damages. It is my legal belief or my legal opinion that until a judgment for money has been entered, the plaintiffs have no right to do anything with Mr. Liner's money, even though he may be legally liable for the wrongful death. There's nothing that allows a garnishment, an execution, or anything else. So potentially, and I don't know that this will happen, but potentially, if the Court of Appeals rules favorably, then money would be available for his defense. In the meantime, though, as I said before, time marches on. This case is set for trial, and no preparation will be undertaken until somebody is representing Mr. Liner.
General, do you know if I were to appoint a lawyer to represent him, do I have authority under the law to order that attorney to be reimbursed at an hourly rate?
Judge, that is an issue that I would have to do some research into, but I am more than happy to.
All right. Well, I'm going to take no action at this point. He is not indigent. It's just he has an impediment to access to his funds. I am going to ask the state to research that issue. I'm going to research that issue. And I'm going to do another attorney status date. It's going to be my next date, which is September 8th of 25, because I want to get a lawyer on Mr. Liner's case, because all of this maneuvering is just eating up the time to prepare. All right, September 8th is your next attorney status date. You take whatever steps you can. Speak with Mr. Lawrence about taking whatever steps on your behalf, because you've got a May trial date. May 12th is your jury trial day.
Your Honor, I will be out of the country on September 8th, so I will not be available to be in attendance. I'll do what I can. In fact, I'm leaving out of the country Wednesday, and whatever I can do remotely, I'll try to do, but that is my status.
All right, well, you're not the attorney of record
I
here.
understand that.
I'm just asking you to help Mr. Liner because he's in a difficult position.
I will give what help I can given the circumstances that I'll be in another country.
All right. Do you have an associate in your office? Is there somebody else that could help?
Yeah, I practice off my wife, and she does whatever I tell her to do.
That's on the record. All right. 9/8 is your court date. Thank you.